Hello, everyone, and welcome to our Essential Tremor Virtual Education Forum. My name is Patrick McCartney, and I'm the Executive Director of the International Essential Tremor Foundation. Today, we're going to be hearing from Chris Gaughan, who will be discussing the importance of estate planning and providing you with information you will need to make an informed decision for you and your family. Before we get started, I want to thank our corporate partners, Medtronic, Insightec, Sage Therapeutics, Jazz Pharmaceuticals, Cala Health, Boston Scientific, Praxis Precision Medicines, and Allevion. Their support allows us to provide these webinars, our podcast series, and our newly started up again in-person ET Education Forum. So thank you to them. So I'd like to introduce our speaker for today, Chris Gaughan. Chris, in February of 2016, was appointed to the prestigious Board of Governors by the American Academy of Estate Planning Attorneys. Known for his ability to provide a wide range of custom estate planning services to his clients, with a primary focus on helping them provide for the security of their loved ones, reduce estate taxes, and minimize or avoid the costs and delays of probate. Chris prides himself on the lifelong relationships he forms with each and every one of his clients. He's a member of the prestigious American Academy of Estate Planning Attorneys, the Kansas City Metropolitan Bar Association, as well as the individual Missouri and Kansas Bar Associations. So welcome, Chris, and thank you for joining us today.
Thank you for having me. I appreciate it. So the talk we're going to go through today is something we put together about 10 years ago for a group of consumers that wanted kind of the basics of estate planning. What are the common mistakes that people make? And so this is kind of the evolution of that, and it's just a talk that goes through the nuts and bolts and maybe even estate planning 101 for people just from a very, very basic entry level. So we'll go ahead and kind of jump in. What I've noticed, and I appreciate the background. Again, Chris Gaughan, estate planning lawyer based in Overland Park, Kansas. That's the Kansas City area. Kind of already read my bio, all that fun stuff. I'm a lifelong Kansas City guy. This is my family. I've got a lovely wife, Kristen. I got 3 kids, Michael, Kevin, and Dottie. And this is why I get to do all this fun stuff every day, as my children, who are now all teenagers, like to eat all the food at our house. So this is how we support them. So our agenda for the day, we're going to go through the top 7 estate planning mistakes that I run into most frequently. When we finish that, I'll go through and explain the solutions to those mistakes and how to fix them and steps on that. We're not going to do a live Q&A today, but there is an opportunity at the end where you can submit questions. If you have more specific things you want to know about or want to maybe flesh out a little more of the information we're going to talk about today. So the first mistake I commonly run into, people assume that if they have some kind of major medical issue, some kind of medical emergency, and they become incapacitated, that their spouse can just step in and take care of things, or their adult children can step in and take care of things. And unfortunately, that is just not the case. Spouses and your adult kids do not have the right to manage your financial affairs. And so, for example, at my house, my wife, for whatever reason, is not on our water bill. If she calls the water company and tries to talk to them, they won't talk to her. It's not her account. And so kind of the same situation. Spouses and adult kids don't have the right to make medical decisions for you if you can't communicate or you are otherwise incapacitated. In fact, because of that little thing they call HIPAA, the federal privacy statute, your family doesn't even have the right to find out what's going on and learn about your medical condition. And so if you don't have powers of attorney, which we'll talk about a lot here throughout the afternoon, but if you don't have powers of an attorney and you get sick or you get hurt, you have to have someone like us go to the court system and have a family member of yours appointed as your guardian and your conservator. So basically, if you don't have powers of attorney, the way that these decisions are all made is someone in your family gets court appointed to do that. And it is very, very expensive, typically anywhere from probably $2,500 on the low end if everyone in the family is getting along and there's nothing squirrely at all, on up to $10,000 or $20,000 if it's kind of a more complicated thing or there's not agreement as to who would be in charge. So then mistake number 2 that we run into, a lot of times folks assume that they don't need any kind of estate plan because their family already knows where things are supposed to go when they die. And a lot of times they even create a helpful set of instructions. And so this is a letter. I took a picture from a conference I went to years ago where this was actually an exhibit in one of the case studies that we were going through. And our office is based in the Kansas City area, so our talk is based on Missouri and Kansas law, but all states have laws similar to this. If you have just handwritten instructions or something informal like this, it almost certainly is not going to be valid. In order to have a valid will, there are all kinds of formalities that have to be followed as far as what language is included and how it's signed and how it's witnessed and how it's notarized. And so these kind of handmade instructions very rarely are accepted as a legal substitute for a last will and testament. And in fact, these handwritten instructions are actually oftentimes worse than doing nothing at all. You know, if I came across a list from my mother that told me she wanted her, you know, her jewelry to go to one of my sisters and her dining room set to go to my other sister and her whatever to go to my brothers, I would feel compelled to follow that, particularly if it's something that, you know, it's her handwriting. I can see that she put it there. The problem is, if I follow those instructions, I don't actually have the legal authority to do that. And so any of my siblings could say, hey, you're distributing assets that you don't have the authority to distribute. We're going to sue you. And so you actually, in that scenario, I would be personally liable for carrying out my mother's wishes simply because they weren't valid, right? I didn't have the legal authority to do them. So oftentimes people are kind of better off not doing anything than doing some informal handwritten instructions for their family. So that takes us to mistake number 3. A lot of times folks assume that they don't need an estate plan because by default, everything goes to their spouse or their kids or whatever. And Missouri and Kansas, just like all the other states, have very specific laws that dictate where assets go if someone dies without an estate plan. So basically, if you die without a will or a trust, they say that you die intestate. That's the legal term, is you die intestate. And when someone dies intestate, basically state law will dictate where all the assets go. And yes, generally it will go to your family. The problem we run into, though, is your individual definition of family may be very different than the state definition of family. And so, for example, let's say that we've got a married couple where one of them was married before and the spouse died and they remarried. Okay, well then, who is the family there? And that is one of the most common things we run into is we'll have a spouse die, the surviving spouse remarries at some point and then dies before the new spouse, and everything goes to the new spouse, right, instead of the children. So anyway, big problem there. A lot of times we have blended families. And so, for example, he's got 2 kids, she has 2 kids. What often happens in that scenario, if they don't have an estate plan, she dies first and everything goes to the husband. And then when he dies, if there's not an estate plan, the assets will go to his heirs. That's his biological or adopted children, not his stepchildren, not his deceased wife's children. So anyway, we just have to be really, really careful because even though state law will direct assets to your family, quote unquote, your definition of family may be very, very different than just the statutory definition used by the state in which you live. And so that takes us to mistake number 4. Well, listen, people go, that's not going to happen to me. You know, when I die, my kids will just sell my house and they'll take the money and they'll do what I want them to do with it. And that's the end of it. And that seems really simple, but there's a problem. There's a bit of a logistical problem. How do they actually sell it, right? Because like if you die, you're the one that's on the deed to your house. Well, how do your kids get your name off the deed so that they can transfer it to a buyer? Or maybe they get your name off the deed so they can take possession themselves. And that's what probate is. When you hear probate, it's kind of the scary, scary term, but it's really just the process of retitling assets when you die. So if you die and you own a house, the probate court takes your name off the deed and puts your kid's name on on the deed as the new owner. Like that's all probate is. It effectively just gives the family the legal authority to, take custody of your assets or to sell them to a third party or transfer them elsewhere. And so very, very easy in concept. The problem, though, is it's really, really expensive. So the amount of time that probate takes varies a little bit state to state. I will tell you that in Missouri and Kansas, the fastest you can go through probate is 12 months. I have a case, so today is April 20th of 2023. I filed a new probate case the day after Christmas, so almost 4 months ago in Jackson County, Missouri, which is where Kansas City is. and the initial round of paperwork hasn't been approved yet. Like we haven't gotten it. All we're waiting for is the judge to stamp it and give it back so that we can start the 1-year clock of all the things that have to be done. So probate takes forever. And the reason that is problematic is, if you have a house, whether you're living there or not, whether there's a mortgage or not, it costs money for it to sit there. And so if the house is stuck in probate for a year or a year and a half or 2 years, your family has to keep paying all the insurance and taxes and utilities. And by the way, vacant homes are crazy expensive to insure. So anyway, that's one big drawback to probate. The other drawback to probate is just the cost. There are costs left and right. There are court filing fees. You have to put notice in the paper. You have to get what's known as a bond. And then, of course, the lawyer, you have to have a lawyer to do probate in most areas. The lawyer fees are significant as well. And so we tell our clients probate fees are typically going to be somewhere in the order of 4% of the gross value of whatever the asset is. So we'll unpack that a little bit. Let's say you have a $250,000 house with a $200,000 mortgage. Our equity in that is $50,000. Unfortunately, that probate fee is not calculated based on the equity. It's based on that top value, that gross value of $250,000. And so if that house had to go through probate, we're looking at a range from $7,500 to $12,500. So kind of quick takeaway on probate, takes forever, right? Very expensive. And then whenever we tell people that, they go, well, that's not going to happen to me because I've got a power of attorney. And so my kids will just sell my house with the power of attorney. Not a problem. Probably the single most common misconception that people have, a power of attorney allows your family to manage your assets while you're alive. And typically, if, when you're incapacitated, you don't usually just let your kids take over your finances. A power of attorney becomes invalid the moment you die. So your kids can't use a power of attorney to sell your house after you die, or your kids can't use a power of attorney to access your bank account after you die. In fact, using a power of attorney after someone's death is an act of fraud in most states, and there are civil penalties and potentially criminal penalties depending on what it is that you do with it. That takes us to mistake number 5. Listen, my spouse and I are both on the deed to our house, and I'm pretty sure that if one of us dies, the other gets to keep the house. Why don't I just put the kids on the deed there with me? And then there's no probate on our house. It's okay. Well, that seems like a nice, simple solution. There are a couple things to be aware of. So the reason that there typically is no probate on a house when the first owner dies is that the property is set up in what's known as a joint tenancy, or the legal term is actually a joint tenancy with rights of survivorship. So you'll see these letters, this JTWROS, you'll see that often on deeds to houses, sometimes on bank accounts or car titles. And it does avoid probate if it is done correctly, but there's a couple things to be aware of. So just because 2 people are identified on the deed to a house, that doesn't automatically make them joint tenants. In the state of Kansas, for example, if my wife and I own a house and it has our names on it, so it says Chris and Kristen Gaughan, husband and wife. Well, that doesn't have the magic language that creates a joint tenancy. We each own the house 50-50, which means that if one of us dies, the other owns half the house, and then the half that belonged to the person that died has to go through probate. So anyway, be aware, joint tenancy does avoid probate if it's set up correctly, but each state has very specific verbiage that has to be included to establish that joint tenancy. And if you don't have that language, there is going to be probate sometime after the death of the first spouse. Where this tends to come up isn't really right away. If we have a client that dies and their house doesn't have the joint tenancy language, it's not like anybody comes and tries to take the house away from the surviving spouse. The problem comes to light, though, whenever the surviving spouse goes to sell the house, because they get 2 weeks out from closing and the title company does their title search and they come back and say, hey, we got a problem. You only own half the house and the other half has to go through probate before you can sell it. Now, having said that, let's just assume that your property is set up correctly as a joint tenancy. And let's just assume for purposes of argument, you've set the kids on you put the kids on the deed with you. So I have 3 children, and this would be my wife and I, and all 3 of our kids as co-owners of our house and as joint tenants with rights of survivorship. Joint tenancy is kind of a funky thing. The reason there is no probate when a joint tenant owner dies is that technically, in most states, each owner owns 100% of the asset. It's this weird kind of legal concept, but that's why there's no probate. And so then, if my wife and I put our 3 kids on the deed to the house with us, what happens if one of my kids gets divorced? Like, whose house is it? Well, in that scenario, my house gets treated as one of their assets. Or like, what if one of my kids, starts a business and it fails and they file for bankruptcy? Or I have a buddy of mine who just this past weekend got served with a lawsuit from an Amazon delivery guy that tripped on his property. Okay, well, if one of my kids had that happen and they get sued by the Amazon delivery guy, like, my house is exposed to their liabilities. So generally speaking, adding the kids to the deed to the property, if done correctly, will avoid probate. It also, though, opens kind of Pandora's box of all these other problems. Now, the last thing I want to touch on this, there are tax consequences to putting the kids on the deed to your house with you. And so you used to hear all the time that people could give away $10,000 a year or $15,000 a year. That number now is $17,000. And if I give my kids more than $17,000 in a year, I have to file something called a Form 709. It's a gift tax return with the IRS. And it's not that there's going to be taxes paid. It just affects the amount that I'm allowed to give them, when I die before taxes come into play. So all that's fine and well. But what happens is when I give my kids a gift during my lifetime, they get my basis in the property. And so let me give you a quick example. I buy stock for $1, it goes up to $10. I sell it for $10. I have to pay capital gains tax, right? I pay a tax on the growth. Well, same example, I buy stock for $1, it goes up to $10. I give the stock to my kids. They turn around and sell it for $10. Do they pay capital gains tax? Well, yeah, because otherwise people would just give their children appreciated assets and capital gains tax would never be paid. But a third example, I buy stock for $1, it goes up to $10. I die and my kids receive it as an inheritance. What happens if they turn around and sell it the next day for $10? Well, there's no capital gains tax at all. Any assets that are given in the form of an inheritance get what's known as a step up in basis. And so whatever the asset is worth as of my death, as of my date of death, that is the kid's basis in the property. So you can kind of see this, the problem here. Let's say my wife and I live in a house for 30 years and we paid $100,000 for it and it's worth $300,000 when we die. If we put the kids on the deed with us while we're alive and they sell it after we die, they have to pay capital gains tax on the growth, right? The $200,000 increase in value. Whereas if the kids get it as an inheritance when we die, no capital gains tax at all, right? You turn around and sell it, no tax at all. And so oddly enough, in many situations, if there's been a farm that's been in the family a long time, a home that's been in the family a long time, the cost of probate is far cheaper than the cost of capital gains taxes that you settle the kids with by putting them on the deed with you. So for all of these reasons, we've got somewhere north of 5,000 households as clients. I don't think we have ever instructed a client to put their kids on the deed to the house with them as a joint tenant. There's nothing really good that comes of it, and there's a whole lot of potential bad that comes of it. So then mistake number 6, we kind of give these talks and folks go, okay, I get it. I got to do something here. I'll get a will, and that will at least ensure my family won't have to deal with the court system. And that's a big fat no as well. Wills don't avoid probate. In fact, wills are just instructions that tell the probate court where your stuff goes. And if you think about it, even with a will, right, we have a will that explains where everything goes. How does your family actually get title? Like if I leave my house to my kids, if my will says that they get my house, well, that's fine and well. How do they get my name off the deed and get their own names on as the owners? We're right back to probate. Like that's the entire purpose of probate. And so even with a will, your family still has to go through probate. Wills don't really do anything unless they get probated. So then you go, okay, well, gosh, if wills have to be probated, what is the point of even having one? Like, why would I have a legal document that's going to force my kids to have to go through the court system? Well, everybody needs a will for a couple of reasons. Number one, someone just needs to be in charge when you die. And I'll give you an example. Earlier, I mentioned that my wife's not on the water bill at our house. If she calls the water company, they won't talk to her. But if she sends them my power of attorney, they will. Well, the power of attorney shuts off when I die. It can't be used anymore. But the will then picks up at that spot, right? So then upon my death, my wife would send a copy of my will to the water company, and the will names her as the executor. And that's where she has the authority to basically step in and start dealing with things. She is the one that's put in charge. She is the one that would have access to information that would otherwise be private. So for example, I have a client I'm helping right now. The client passed away, or helping the family. There was a bank account out there that none of the kids knew about. And the bank, of course, won't tell the kids what kind of account it is, how much money is in there, what the account number is. And so we're using all these legal documents just to get information, right? Just to find out what's going on. Now, the other reason that people typically use wills, our clients tend to have children that are grown up and are no longer minors. But if you have minor children, a will is where you would name guardians. That's where you name the people who would raise your kids if something happens to you. Now, that does affect our clients in a bit of a roundabout way, because I will tell you, like if my wife and I died, and our kids are going to have to be raised by someone, boy, my parents sure want to have some input in that. They at least want to see their grandkids, right? And so anyway, the other utility of wills, in addition to just getting information and having someone in charge, is if you do have young children, or even if you have grandchildren, the will is the document that identifies who would raise those kids until they become adults. So pretty much everybody needs a will. Then the real question is, do you need a will and a trust on top of it, which we'll talk about in just a moment. So then mistake number 7. There are many, many people who avoid probate by just naming beneficiaries on all their bank accounts and life insurance and retirement. And in some states, you can even name a beneficiary on your home. They call it different things in different states. Sometimes it's called a transfer on death deed. Sometimes it's called a beneficiary deed or a ladybird deed. But basically, sometimes folks go, okay, this probate thing sounds awful. Why don't I just name my family as beneficiaries on everything, including my house, and then we at least don't have to deal with the court system. And, that's kind of, we always refer to that as the poor man's estate plan. It works actually pretty well for financial accounts. Naming your kids as beneficiaries on IRAs and, Roths and bank accounts and all that works phenomenal. It's where real estate comes into play that problems tend to bubble up. And so about half the states allow you to name a beneficiary on your home. We generally don't do that for 2 main reasons. So number one, when a house is set up to transfer on death to your children, when does the transfer take place? Well, it takes place at your death, right? It's common sense. Okay, well then what happens if one of the owners is alive but incapacitated? And so I have an aunt right now with dementia. I've been her power of attorney and trustee for a long time now. She physically can sign things, but no notary will ever attest that she understands what she's signing and she has legal capacity. And so with transfer on death, the problem is that families can't sell these houses if the owner is incapacitated. They have to wait until they die. And particularly, most states have what's known as a 1 to buy, 2 to sell rule with real estate, which means that it takes both spouses signing off on the sale of real estate for it to be effective. In fact, when my wife and I got married, I already owned our house. She wasn't on the title. She wasn't on the mortgage, wasn't on any of the bills. But from the minute we said I do, I could no longer sell the house without her signing off. And so, well, gosh, we have all kinds of problems then if one of the spouses has a major health issue. The second, though, and the main reason that we typically do not name beneficiaries for houses is what happens after that. And so my wife and I have 3 children. If we were to pass away and leave our home to our children with a beneficiary deed or a transfer on death deed, we are effectively leaving the house to all 3 of our kids, as well as all of their spouses, right? Because all of the kids would have to sign off on the sale of the home. And because there's a 1 to buy, 2 to sell rule, all of their spouses have to sign off on the sale of the home. So then what happens if one of the kids gets mad? Or what happens if one of the kids is in the middle of a nasty divorce and their spouse won't sign the paperwork? We get these calls all the time. We say, well, the solution is real easy. You give that spouse some of the money. So by and large, because of these problems with transfer on death, with real estate, it's pretty rare that we use beneficiary deeds or transfer on death deeds. We tend to put real estate in trust much more often than not if we're trying to avoid probate. And so we'll kind of jump into what trusts do and how they address these problems. A trust, in many ways, kind of the easiest way to think of it is like a treasure chest or a box that holds all of your stuff. And so you take all of your assets and you put it into this treasure chest. And I have some fun graphics, like we'll put your house in there and we'll put your investments in there and your bank account and your family loot bag that everybody has, of course. We take all this stuff and we put it into this box. And then on the outside of the box, we have a set of instructions that explains who's in charge of all this stuff if you become incapacitated, who's in charge of all this stuff when you die. And there's also instructions on where everything goes. Now, where a trust differs from a will is this second paragraph here on my little page. A will tells the probate court where your stuff goes. A trust has its own legal authority that allows the trustee, the person in charge, to sell your house or retitle it in the name of your children, or transfer it to one of the kids, whatever it is it might be. So a trust really, it's like a will, but it has its own mechanism for passing assets on, for actually causing the transfer of assets after you die. And so when you have a trust, there are three kind of key terms, three jobs. There's the trustor. That's the name of the person who creates a trust and puts their assets into the trust. There is a trustee. That's the person who manages whatever is in the trust. And there is a beneficiary. That's the person who uses whatever is in the trust. And when you have a trust, you typically would occupy all three of those jobs. You are your own trustor because you obviously set your own trust up and defined its terms. You are your own trustee. You're in charge of all your own stuff so long as you're alive and in good health. And you are also your own beneficiary. You continue to use your stuff. So my house is in a revocable trust, and my wife and I are beneficiaries because we live there with the kids, right? We're using the house that's in the trust. Typically, most estate planning trusts are set up to be revocable. We could do a whole other talk on irrevocable trust, but that's a little bit beyond a kind of a basic course like this. But the trust is revocable or changeable during your lifetime. And then upon death, the trust becomes irrevocable. So your family can't come do something different than what your wishes are. If you have your assets in your house in a revocable trust, it doesn't change like your mortgage. You can still buy things, sell things. My wife and I, our trust has been in the same form for the better part of 15 years. We've owned 3 different houses during that time. We've never had to go change the trust when we moved. Instead, we just put the name of the trust on the deed to the new house we were buying. A revocable trust doesn't change your income tax forms, doesn't change your property tax bill. Life kind of just always goes on as usual. So if nothing's really any different, what exactly is the purpose of a revocable trust? Well, you're the trustee in charge of it while you're alive and in good health. And then you name a successor trustee who would step in and oversee it if you become incapacitated or pass away. So, for example, the successor trustee could manage your finances, could pay your bills, could sell your home. I go back to the example of my aunt with dementia. When I sold her home, she physically could sign the deed, but no notary was going to attest that she understood what she was signing. Well, that was okay. I had her house in the trust, and I had taken over as successor trustee because of her incapacity. And so when I sold her house, I literally signed the deed, my name, comma, trustee of her trust. Like that was it. When you die, your successor trustee can use your assets to pay your final expenses, to sell your house, to whatever it is it's going to be. So really, a trust is just an alternative to the probate system, right? It's a way to sidestep the probate system. So are there other benefits to a trust besides that? Yes, we'll get into those in a second. But the big reason people tend to use trust is to avoid probate. They don't want to have a problem selling the house if the owner's incapacitated. They don't want to have to go through formal probate when the owner dies. Basically, trusts just allow you to deal with things privately outside of the court system as quickly as you want to. Now, having said that, there are some other advantages of having trust. My wife and I in particular, we want to make sure that if one of us dies and the other remarries, that's all perfectly fine. But in that scenario, it's very important to us that our assets would still ultimately go to our kids. My wife doesn't want everything going to my new hussy wife, as she always puts it. My wife gives me grief that she would be happily single if something happened to me, and then I would bring a date to her funeral. And it's only funny. It's not true, but it's only funny because it has just a nugget or a kernel of truth within it. But trusts are commonly used to make sure that whatever assets are accumulated together would always go on to the children, even if one spouse dies and the other remarries. In our particular instance, our trust is set up so that if one of us dies, the other has use and control of everything. If the surviving spouse remarries, the trust says, hey, you got to have a prenup with the new person in order to keep using the trust. That's all we've done. And so then if my wife dies and I remarry without a prenup, the money just goes straight to the kids. It's not that my wife and I don't trust each other. We just don't want things to accidentally go somewhere else. Trusts are also very, very helpful to make sure that inherited property stays with your children if they ever get divorced. You know, there's a 1 in 500 chance your house would burn down, but you'd be kind of a fool to not have fire insurance. There's a 1 in 2 chance the kids would get divorced. The divorce rate is about 50%. And so trust can be utilized just to make sure that whatever goes to the kids remains their separate property and would thus remain with them if they had some kind of marital falling out and got divorced or whatever it is it might be. It's just a way to make sure that things, again, go where you intend, but also stay there if life throws a curveball your way. If you're not a fan of 80s movies, this is Cousin Eddie. I love all the vacation films. And so sometimes families have a Cousin Eddie in it. Someone who's maybe not very good with money, or someone who's not financially responsible, or someone who is allergic to work, or whatever it is it might be. And so trust can be used to ensure that money that goes to people like this, the inherited money benefits them, but can't be garnished, or it can't be subject to to back taxes, or the money's protected from unpaid alimony, or from a bankruptcy proceeding, or whatever it is it might be. Trusts are very helpful to ensure that if we've got some financial management or maybe mismanagement issues with the kids, that the money that you leave them will be protected from third parties and can't be taken in a lawsuit or that sort of thing. Trust can also be used to create incentives. And so as an example, in the trust my wife and I have, our kids are still young, but we've structured things in a way so that if we die, once our kids finish a 4-year undergraduate program, the trust would release some money to help them pay for a down payment on a house, right? And so trust can do all kinds of things, incentivize anything you want. I have some clients that set it up where they say, hey, my kids are lazy and they're going to live off this and not have a job. So they say, okay, what I'll do is I'll set it up where whatever money they make every year on their own, they get that amount of money from the trust I'm leaving them. So they only get money from me if they go earn something on their own. Anyway, trust can be used to create all kinds of different incentives. Trusts are commonly used for young families. This is actually a picture of my children when they were younger, and I have this picture in here for a very particular reason. My wife and I send our kids to a Catholic school, and because of that, we are required to go to an auction about every third day. That's like the Catholic thing. And so one of our kids' school auctions years ago, they had a deal where you could pay like $500, and you got a portrait sitting, and you got a little 9x12 portrait of your kids. And we hadn't had a picture of the kids in a while. And so we said, hey, let's buy that. That's great. And so anyway, my wife has access to my work calendar. She can't see what's on it. She can only see when it's busy or not busy, though. And it was kind of weird because she scheduled this photography shoot on a day when I was booked just totally back to back to back, no lunch, no time for anything else. And I didn't really think much of it. Anyway, she took the kids that day and did the sitting. And I got home that night and I said, how was it? She goes, oh my God, it was just the best thing ever. They had this little wooded area behind the studio. And one of my kids is on the autism spectrum, and the photographer had a nephew who was on the spectrum and kind of knew how to communicate with our son. And the kids splashed around and played. And it was like this otherworldly customer service experience for my wife. And I kind of chuckled and said, man, it's a lot of value for $500. That's awesome. And then I happened to look down at the counter and the pile of mail, and there was this big yellow carbon paper receipt. I thought, boy, that's odd because we paid for this at the auction. My wife had gotten so overwhelmed and excited at the photographer's studio that she bought a 4-foot by 3-foot version of this picture to hang over our fireplace for nearly $3,000. And I was steaming mad for about 10 seconds. But then it occurred to me, for a living, I do tax planning. Why don't I just put this into my talks and then I can write it off? So I have this in here for a very particular reason, and that is it. But also, in addition to that, trusts are just commonly used if money is going to go to younger beneficiaries to ensure they don't get the money all at once. Like with my children, if my wife and I die, one of my brothers oversees the money for the kids. He can pay for health insurance, medical care, tuition, food, clothes, shelter, whatever. Whatever money is left, my kids get in phases. They get some when they're 25, some when they're 30, some when they're 35, some when they're 40. I just don't want them coming into a big chunk of money at a young age, and I don't want them coming into it all at once. So the last common use of trust, we have lots and lots of clients who have children or grandchildren who are getting Medicaid or SSI. And so in situations like that, you cannot leave those kids or grandkids money outright. If you have more than a few $1,000s to your name, you're going to lose Medicaid. And so oftentimes when we have clients who have kids or grandchildren in this position, we say, okay, whatever money you're going to leave them, let's have it held in a special needs trust. And a special needs trust basically means that the money doesn't count for purposes of Medicaid or SSI or Section 8 housing or some of these other means tested programs, but the money is available to supplement those benefits that the kids are receiving. So anyway, very, very common use of trust. So as we kind of head into the fourth quarter of our talk here, okay, how do I know if I need a trust or a will? Like, is there some like criteria we use? Well, pretty much everybody needs a will, for the reasons we talked about earlier. The real question is, do you need a trust in addition to a will? And these aren't perfect rules, but I've just got some criteria that we tend to use when we explain these things. Wills are intended for more common situations, kind of vanilla situations. And so, for example, if you don't own a home, a will is probably going to be just fine, right? There's no it's so easy to avoid probate on everything but the house that if you don't own a home, usually a will is going to be just fine. If you have a simple situation, will's probably going to get the job done. But I have one caveat there. Oftentimes, people that tell us they have a simple situation, once we dig into it, it's actually like 10 times more complicated than the average situation. So there's a little bit of a perception issue on that. But truly simple situations, we do tend to use wills. From an asset standpoint, if you add up the equity in your house, investments that you have, life insurance, personal stuff, if that starts creeping up close to about $500,000, and that's when we start looking at trust. So if you're below that $500,000 in household wealth, a will is probably going to be just about fine. And the reason on that is at that level, it's not good or bad, but you're going to use a pretty good chunk of those resources throughout your life. And there probably won't be a whole lot left to pass on as an inheritance to your kids or grandkids or nieces or nephews or whatever. Trusts are much more commonly used when people own homes, particularly if they have a lot of equity in their home. Trusts are commonly used, where I mentioned with my wife and I, if one of us dies and the other remarries, we just want to make sure that everything stays with our kids and doesn't accidentally go to a new spouse. If we're not so sure about the kids' spouses, trusts are very helpful to address that. If we've got a beneficiary who has money management issues or they're young, again, trusts are commonly used for that. Beneficiaries with special needs, all of these are circumstances where we would probably lean towards a trust instead of just a simple will. And purely from a financial standpoint, if we add up all your household assets, again, equity in the house and bank accounts and investments, those things, if it starts creeping up over about $500,000, we're almost always going to be looking at trust there. And then one big kind of catch-all at the end, if there's some other family dynamic that necessitates it. I have a very, very nice young client. I just helped with some stuff. She doesn't own a home. She's got a sizable term life insurance policy though that she put together for her disabled son. And so it has to go into a special needs trust. There's no other way to leave him the money where it's going to protect the benefits that he is receiving. And unfortunately, he has very expensive care needs that will continue throughout his life. So sometimes, there's just a kind of a family dynamic that necessitates it. Now, regardless of whether you have a will or a will and a trust, everybody needs these documents as well. So the first is a property power of attorney. Sometimes you'll hear it called a financial power of attorney. This is the document my wife uses when she calls the water company. And she says, hey, I know I'm not on the bill, but I need to get information so I can pay it. Well, she sends them my property power of attorney. She steps into my shoes and handles things for me. Likewise, earlier this week, even though my background's accounting, I had a CPA do my taxes, so I get a second set of eyes looking at our stuff. And I ran over to sign our paperwork with the CPA. I went by myself and I signed the tax return as me. And then I showed them her power of attorney and I signed it as her. So it lets us just kind of take action on behalf of each other. Everybody also needs to have what's known as a durable healthcare power of attorney. Same idea. That's the document where my wife and I have given each other the authority to make medical decisions in the event of an emergency. You can name as many backups as you want. And so we both have kind of different backups. Our kids are not yet old enough to be in that position. But if your kids are adults, typically they would be, in that role. Everybody needs to have what's known as a living will. Some places call it an advance directive. It's basically the same thing. There are different rules state to state on this, but one rule that is consistent is pretty much in every state, if you get hospitalized or you go in for surgery, they are required to ask you for your living will or your directive, or at minimum are required to ask you whether you have one. And what a living will does is it just says, hey, listen, if I'm terminal and I'm vegetative and the doctors have said this is it, I'm not waking up, don't just keep me lingering, right? Don't artificially prolong the dying process if there's no hope of ever getting better. And there's kind of a more sophisticated version of that people use if they are dealing with a terminal illness, or they are dealing with, like they're in hospice, for example. And that's where we use something called a treatment directive, where you say, hey, I don't want CPR, or I don't want hydration, I don't want dialysis. We use a broader version when people are healthy, and then a more specific version once we kind of know, okay, this is the path we're on, these are going to be the health challenges I face, and these are the types of care I want, the types of care I don't want. Everybody needs to have what's known as a universal HIPAA authorization. So HIPAA, again, is that federal privacy statute, makes it hard to get medical information. You can pre-authorize your spouse, your children, friends, family, whatever, and sign a universal HIPAA that they can present to any hospital, any doctor, any lab, any nurse, any therapist, and be able to get updates on your condition. And so I go back to my aunt with dementia. I had to get her signed up for a teeth cleaning the other day. And so I had to call the dentist just to find out when she last did that. Well, that's information that's protected by HIPAA. And so I had to send over her HIPAA form that said it was okay for me to get that information. And then everybody needs to have what's known as a personal property list. So if you have a will or a trust, in every state, you are allowed to have what's known as a personal property list. And that is a list that's an exhibit to the will or trust, where you can kind of itemize and dole out individual property to people. So, for example, I have 2 boys and a little girl. My wife would have all of her jewelry go to my daughter, not to my boys, right? Or like when my grandfather died, I received his gold watch. Like it's kind of for sentimental things, for family things, for, personal things, items of that nature. As we kind of wind things down, every time I ever talk at anything related to estate planning, the question everyone asks, like the very first thing out of their mouth, is how much does it cost to do an estate plan? So I just put in what we charge so that you would kind of know. We are right in the average range for the Kansas City metro area. So like for married couples, for example, if we do a trust and then we do what's known as a pour over will, when you have a trust, you use something called a pour over will that just says everything you have goes to the trust when you die. So basically anything left out by accident pours over into the trust. But anyway, if we do a trust, pour over wills, directives, powers of attorney, all the different legal documents we mentioned, we charge a flat fee of $43.50 for married couples and $32.50 for single people. That's kind of the normal range. If a fee is much, much higher than that, you better have something a lot more complicated going on. Otherwise, you're probably overpaying. And if the fee is well below that, my guess is that the lawyer probably dabbles and is maybe a general practitioner that does a lot of different things as opposed to just one particular thing. But anyway, that's what we charge when we do trust. When folks have simple situations and we do, a will and all the powers of attorney and just kind of the simpler version of it, married couples, we charge a flat $19.50, singles, we charge $15.50. Again, that's the range you should probably expect in a metropolitan city that's roughly the size of a Kansas City or a St. Louis or something with 2 million people approximately. That's kind of the going rate. So as we kind of wind things down, oftentimes when we do these talks, folks go, man, there's all kinds of stuff I didn't know. I wonder if I need to do this or if I should do that. When people call my office off the street and want to come visit with one of our lawyers, we always charge them $435 to come in because we get all these crazy nutty people that find us online. And this is how we make sure that we kind of keep away from some of that. But if someone comes to one of the webinars we've attended, this is all the stuff we talk about at that first meeting anyway. So anyway, if you want to learn more about it, we don't charge if folks that come to one of our webinars. We just kind of talk about your situation. There's really not much you have to do to prepare for it. But go through your family and finances and things like that and just say, hey, here's what we think you ought to do. If you would like to learn more about that, I'm going to leave this screen up here for a moment. We have an info email address at my office. It's info@midwestestateplan.com. If you'd like to just chat about your situation, by phone, by Zoom, whatever, just put this code "Spring is here" in the subject line for the email. My staff will get it and they will know that you came to one of the webinars and they'll follow up with you. Just make sure you have your name and address and phone number so like we know who it came from. Likewise, anytime I speak at anything, I always, anyone that attends, we give a copy of our book if they would like it. My business partner and I wrote a book that is a little bit more comprehensive version of what we've talked about here today. And same thing, if you'd like a copy of our book, it's free. We just ship it out as kind of a courtesy to folks. You'd send an email to that same address, info@midwestestateplan.com. Put spring is here in the subject line and just put your name and address so that my staff knows where to send it. So we're not taking live questions. I think that kind of brings us to the very end. So I'll leave this up here for just a moment so you can write that down if you'd like it. And are there any other follow-up items that you would like from me, Mr. McCartney?
Chris, funny you mentioned I had written a note down to ask you about cost of, because that generally comes up just in even discussions I have with individuals about it. I'm kind of curious if you can kind of go back, and you had mentioned before, but the cost of paying for that trust / estate plan / will versus going through probate is quite significant.
Yeah, generally speaking, homeownership tends to be the biggest factor we look at on whether we should do a trust or not. If you have a house worth $100,000, the probate fee is probably going to be more than the cost of a trust. And there's not a lot of $100,000 houses out there anymore. The housing market has gotten just insane. It's funny, these numbers, that the number I used in the example with the $250,000 house, I put the first version of these slides together like 12 years ago. So that was from way back then. So, as a general rule, one of three things happens to homeowners when they die. Number one, sometimes folks are just, on fumes till the end and have to borrow against their house just to survive, and they have reverse mortgages or whatever. And in that scenario, the kids typically just walk away from the house. They just hand the keys back to the bank. There's not enough equity to justify it. Scenario two, if the house has some equity in it, has to go through probate, and the kids end up shelling out a lot of money. Or scenario three, if there's a house, we put it into trust typically. And once the break-even point on that, if you own a piece of real estate that's worth more than about $100,000, the cost of the trust is always going to be a better deal, and it just becomes orders of magnitude more of a better deal, as the value of your real estate goes up.
One last question before we wrap it up. So as a nonprofit, and I have this in my trust with my wife and I, details on where certain causes that we support and amounts or percentages of our estate that go to those in our passing. Would you recommend that, or is that?
Yeah, absolutely. So your timing on this is perfect, because I'm actually I sit on our planned giving committee at our church, and I'm in the process of putting together a talk on all the different ways from a tax standpoint to leave money to charities. You absolutely can do it within the trust. I will tell you, there's a couple of things to be aware of. So number one, the tax benefits of giving money to charity tend to be bigger if you make the gift during your life than they are at death. You get a little more bang for your buck. And so one of the things that we encourage folks to do is to consider using something called a QCD, a qualified charitable distribution. And that's basically a thing where once you are 70 and a half, you can have money go straight from your IRA to a charitable organization. And the money never flows into your bank account, never goes onto your taxes anywhere. It ends up being basically a backdoor tax deduction for people who give money to charity but don't itemize. My wife and I absolutely we have some monetary gifts to charity in our trust. And my thinking on it is that we're going to, once our kids are grown up and are kind of off our payroll, we will probably make much bigger gifts in our lifetime and then kind of peel that back and have less and less going to charity at our death. Again, because the tax benefits, you tend to get a little bit more bang for your buck. The other thing too, a lot of our clients set up what's known as a donor advised fund, which is basically a simplified version of a foundation. And my wife and I have one of those as well. And a donor advised fund allows you to give money to basically get the tax benefits of giving money to charity when you want them, but you can decide at a later time, like which charities are going to get it, how much they're going to get. I think in my head, I have this dream that may not come to fruition, but where we have a whole bunch of money set aside like that, and my kids get to work together to decide, what organizations are near and dear to them. So because we have a child on the spectrum, we tend to do a lot with autism causes. And I suspect that my children will do as well. But anyway, that was a long lawyerly answer to say, yes, we absolutely look at charitable bequests within trust. But sometimes there are other ways to do it where basically the charity gets a little bit more money and the federal government gets a little bit less, or, we kind of squeeze some efficiencies out of it.
Excellent. Well, thank you, Chris. I appreciate you taking the time to speak with us today and share some great information on estate planning and the things that you need to do to make sure you get it done right. We hope everyone found this presentation very helpful. Hopefully you learned something new today. I know I did. If you have any questions regarding Essential Tremor, please visit our website at essentialtremor.org, or you can call us toll free at 888-387-3667. And finally, if you are a donor to the IETF, we want to thank you for your support. If you aren't currently a donor, please consider a gift to help us continue the work we do promoting ET awareness, education, support, and research. And along the lines of this presentation today, we hope as you're putting your estate plan together, you consider the IETF as maybe one of your gifts or beneficiaries in your trust agreement. So we're going to be hosting a variety of these virtual ET education events in the upcoming months. So look for notices about these events in your Tremorgram e-newsletter, our social media channels, and our Tremor Talk magazine. Thank you again for joining us today again, and thank you, Chris, for joining us. Hope everyone has a great day.